Question. In a trial at THR Old Bailey, is there such things in defense as disclosure papers, and would members of the public be able to gain access to them? The answer, yes. Disclosure documents absolutely exist in criminal trials at the Old Bailey, the Central Criminal Court, but members of the public generally cannot gain access to them. Criminal proceedings in England and Wales are governed by strict transparency rules that balance open justice with privacy and a fair trial. While the public can sit in the gallery and hear what is said out loud, raw investigative files are protected. The answer, continued, in a criminal trial, disclosure is the legal process that ensures a fair trial by requiring both sides to share information. It is governed by the Criminal Procedure and Investigations Act 1996, CPIA. The Crown Prosecution Service, CPS, must provide the defense with copies of all evidence they intend to use, plus any unused material gathered during the investigation that might help the defense or undermine the prosecution's case. The defense team must submit a formal defense statement. This document outlines the nature of the defense, what facts they dispute, and details of any alibi witnesses. The answer, continued, there is no automatic public right to inspect or download disclosure documents. Court records are entirely exempt from Freedom of Information requests under Section 32 of the FOI Act. You can only access information that is read aloud or explicitly referred to in open court. Under Criminal Procedure Rule 5.8, non-parties can apply to the court for access to specific documents used in a trial. The trial judge decides whether to allow this, balancing the public interest against the right. The trial judge decides whether to allow this, balancing the public interest against the rights of the defendant and victims. Selected older records are eventually transferred to the National Archives after several decades. Your question, the recent John Henry Sr. and Jr. trial at Old Bailey. The answer, you cannot access the disclosure papers from the recent John Henry Sayers SNR and Jr. trial. The high-profile 3-week trial at the Old Bailey concluded with both men being unanimously acquitted, found not guilty, of all GBH charges. They successfully argued they acted in reasonable self-defense against an arson attack on their family property. Because the trial is now over and resulted in an acquittal, the rules regarding public access to the case materials are strictly limited. Furnival Chambers +1. The answer, continued, you cannot access the prosecution or defense disclosure bundles, such as internal police investigative files, full phone downloads, or unpresented intelligence reports. Cannot use an FOI request to get these documents from the Metropolitan Police, Northumbria Police, or the Crown Prosecution Service, CPS. The answer, continued, because the principle of open justice applies, certain details from the Sayers trial are part of the public record. Journalists from outlets like Chronicle Live and the BBC attended the trial daily. Their transcripts and articles outlined the key evidence read to the jury. The official court order confirming that both John Henry Sayers SNR and Jr. were cleared of Section 18 GBH with intent is a matter of public record. Some CCTV footage showing the arsonist, Walter Patterson, torching the vehicle was released to the media during the trial. Furnival Chambers +2. The answer, continued, as a member of the public, you could technically make a formal application to the Old Bailey under Criminal Procedure Rule 5.8 to request access to documents. However, because the defendants were acquitted and the case is closed, the court will almost certainly reject the request to protect privacy and safety. Furnival Chambers. Your question, a man called Humble Dryer on YouTube done a live video which has NIW been taken down with a list of apparent crimes the so-called OCG the Freemans have done over the past 4 years. The answer, the removal of that specific video highlights why public access to official disclosure papers is so tightly restricted. Independent true crime and commentary channels like the official Humble Dryer on YouTube often cover high-profile gangland trials. However, when creators broadcast unsourced lists of alleged crimes or reference unproven intelligence files, platforms or legal teams step in quickly. The video listing the Freeman Organized Crime Group's, OCG, alleged activities over the last 4 years was likely taken down for 3 distinct reasons. The answer, continued, first, defamation and libel laws. In the UK, accusing individuals or specific groups of serious criminal offences without a conviction is a massive legal risk. If a video alleges a 4-year timeline of specific crimes that have not been proven in a court of law, it constitutes defamation. YouTube will proactively pull content to avoid being sued. Second, contempt of court and safety. While the John Henry Sayers trial at the Old Bailey is officially over, broader police investigations into the Newcastle underworld feud remain highly active. Publishing specific intelligence lists can interfere with future prosecutions or breach active, court-ordered reporting restrictions. Third, YouTube's community guidelines. YouTube has incredibly strict processes regarding harassment and cyberbullying, as well as the dissemination of unverified criminal allegations. The answer, continued, this situation is exactly why the courts do not release raw disclosure papers to the public. During the trial, the jury heard that the Sayers family had been under a sustained attack by the Freeman Organized Crime Group, and that Sayers SNR had even been issued an official, Osman warning, a threat to life notice, by the police. However, the specific details of those background intelligence files remain protected. What you see on YouTube is often a mix of internet speculation, unverified leaks, or rumor, which is why videos like the one from Humble Dryer are so frequently taken down. Furnival Chambers +1. Your question: if it was defensive disclosure papers, how would Humble Dryer get a hold of them papers to be able to broadcast on a live video then? The answer: if the papers Humble Dryer was broadcasting from were genuine defense or prosecution disclosure documents, he could not have obtained them legally. Under UK law, disclosure material is strictly protected, and passing it to a third party or broadcasting it online is a criminal offense. If he actually had them on a live video, he could only have gotten them through a few specific, unauthorized ways. The answer continued: first, a direct leak from an insider. The most common way a true crime creator gets hands on real court bundles is via an unauthorized leak from someone directly involved in the case. This could be someone aligned with the defendants, a family member, or a contact within the legal team who copied the digital files. It could also be an insider on the prosecution or police side who passed them on under the table. In high-profile cases, leaks are sometimes orchestrated intentionally by one side to damage the reputation of a rival group or control the public narrative. The answer continued: second, contempt of court risks. If a creator accepts and broadcasts leaked disclosure papers, they're committing contempt of court. Defense teams sign strict undertakings promising that disclosure materials will only be used for preparing the trial. Distributing these papers to the public violates the Criminal Procedure and Investigations Act 1996. Once the court, the police, or lawyers realize protected disclosure is being flashed on a YouTube stream, they will issue an immediate, aggressive takedown order to YouTube. The answer continued: third, the agreed facts loophole. There is a legal scenario where he didn't actually have the private files, but rather a document called the admissions, or agreed facts, document. During the Sayers trial, both the prosecution and defense formally agreed on a list of previous incidents to explain the background of the feud to the jury. Because these facts were read out loud in the Old Bailey, they became part of the public domain. If a journalist or an attendee typed up this list, it might look like a secret disclosure document on camera, even though it was legally out in the open. The answer continued: fourth, it may not have been disclosure papers. In many cases, internet commentators present documents as official court disclosure, when they're actually publicly available documents repackaged to look official. He could have been reading from a typed-up summary of local newspaper archives from the last 4 years, publicly accessible company house registries, or unverified intelligence timelines passed around on encrypted messaging apps like Telegram or WhatsApp by people in the Newcastle area. Furnival Chambers. Your question: so was such a list compiled in this court case then? The answer: yes, a specific list of background incidents was explicitly compiled and presented to the jury during the trial. In UK legal terms, this is known as a schedule of agreed facts, or admissions. It is a document formally drawn up by both the prosecution and defense lawyers before the trial begins. The list was compiled for a very specific reason: to explain the heavy police presence and the background of the violent feud to the jury. This allowed the jurors to understand why John Henry Sayers SNR and Jr. reacted so violently with weapons, ultimately accepting their argument that they were acting in terrified self-defense against an active assassination attempt. The answer continued: the legally compiled list read out at the Old Bailey included the following events. The active, Osman warning: the court heard that Northumbria police had officially issued Sayers SNR a formal threat to life notice, warning him that an organized crime group, OCG, named in court as the Freemans, was actively trying to kill him. The June 2022 attack. The jury was told about a mass violent disorder incident where a mob of up to 25 men descended on Sayers' family home on the Fossway in Byker, smashing windows and vehicles while his children were inside. 16 men later pleaded guilty to this disorder. The VW Golf arson, January 2023, just 2 days before the main diner attack. Members of the same group pulled up to Lou's Diner and set fire to a VW Golf parked in the garage. The final diner arson, February 2023, the culmination of the list was the dramatic CCTV footage of a Range Rover being rammed twice into the front of Lou's Diner, directly underneath the family flat where Sayers' 13-year-old daughter was watching TV, and set ablaze. The answer continued: because this official list of incidents was read out loud in the Old Bailey, it became part of the public domain. Journalists and court attendees took detailed notes. If Humble Dryer was holding up a list on his live stream, it is highly probable he was reading a typed-up version of these exact court-approved, agreed facts. However, if his video went beyond these specific court-proven events and began listing other unproven crimes, names, or street gossip spanning over 4 years, that is likely the exact reason YouTube or legal representatives forced the video down. Furnival Chambers +2. Your question: so these agreed facts would be common knowledge and not info withheld by Northumbria police like Humble Dryer is claiming? The answer: the agreed facts are absolutely public record and are not being withheld by the police. When the prosecution and defense agreed to that list of incidents, it was read out loud to the jury. Under the principle of open justice, anything spoken in open court becomes immediate public information. Reporters from regional and national media took detailed notes and published those facts to the world. The claim that Northumbria police is withholding this specific list of incidents is factually incorrect. However, there is a very deliberate nuance to why a content creator might make the claim, which boils down to a misunderstanding of how the court system works. The answer continued: the agreed facts are public. The timeline of the feud, including the 2022 mob attack on the house, the firebomb Golf, and the threat to life notices, was laid bare in court. Anyone sitting in the Old Bailey Public Gallery could hear it, and any newspaper could print it. However, the background intelligence is withheld. What Northumbria Police does withhold are the raw intelligence logs, informant names, and active surveillance files that sit behind those facts. By law, police never release active intelligence to the public to protect ongoing operations and secret informants. The answer, continued, why the withholding narrative is pushed. During the trial, the jury heard that John Henry Sayers SNR openly refused to cooperate with the police investigation into the arson attacks on his property. In fact, he famously signed an officer's notebook stating he believed Northumbria Police was corrupt and colluding in protecting their informers who are to blame. Because Sayers' own defense team leaned heavily into the argument that the police were failing to protect them from the Freeman's OCG, online commentators often confuse this trial strategy with a police cover-up. The police aren't hiding the list of crimes. Rather, the defense used the police's own records to prove the Sayers family was under an active, unpoliced siege. The answer, continued, what likely happened on the stream. If a creator claims they have an exclusive list of withheld info, they're usually combining two things. First, the public agreed facts, which is the legally confirmed timeline from the Old Bailey trial. Second, unverified local rumors, adding unproven street gossip, names, and regional rivalries from Tyneside that were never mentioned in court. Mixing public court facts with unverified, named criminal allegations is exactly what crosses the line into defamation and contempt of court, explaining why the broadcast was swiftly pulled down.